Good morning, everyone, and thanks for joining JINSA for an emergency webinar. We heard yesterday, Thursday, November 21st, that the International Criminal Court has issued arrest warrants for Israeli Prime Minister Benjamin Netanyahu, former Israeli Defense Minister Yoav Gallant, but also Hamas leader Mohammed Deif, who is presumed to be deceased. I'm Blaise Misztal, JINSA's Vice President for Policy, and very pleased to be joined by JINSA's own legal eagle, Professor Geoffrey Korn, a fellow with JINSA and the Killam Chair at Texas Tech University Law School, and a member of many of JINSA's task forces looking at law of armed conflict issues, as well as JINSA fellow and former State Department official Gabe Noronha. Thank you both for joining us today. Gabe, maybe I could just start with you because unfortunately over the course of the last 13 months, there's been a lot of international courts wading into the Gaza war and the broader conflict in the Middle East. And there's a lot of acronyms we've heard before from the ICJ. Now we're hearing from the ICC. Could you sort of distinguish the alphabet soup of different international courts and tell us who we're hearing from and who this arrest warrant comes from that we had yesterday?
Certainly. So the ICC is a relatively new invention. It exists as a creation of what's called the Rome Statute, which was created to develop this court to basically with the intent of governing the ungovernable and bringing warlords to justice in Africa, and basically stepping in where justice was failing was the intention behind it. The United States was never a party to it. Israel was never a party to it. And that's separate from the International Court of Justice, which is a longer body, a history of a body with a longer history, whose principal job is to mediate disputes between nations. And so whether those are civil or diplomatic treaties, basically a system to arbitrate disputes. The ICC, though, is more of an independent body that is designed to go after individuals for several specified crimes, and then it really rests on the parties to the Rome Statute to actually carry out a lot of this justice, to bring and apprehend people, and then deposit them before the court for a tribunal.
Right. So the, I guess, still ongoing case accusing Israel of genocide brought by South Africa is in front of the ICJ, the International Court of Justice. This is a case in front of the International Criminal Court, the ICC. And so, Professor Korn, maybe you could walk us through the process a little bit, because it was, I believe, earlier this summer, maybe in June, that we heard that the ICC prosecutor asked for arrest warrants. They've now been issued. Can you sort of explain the process of sort of at the, what the prosecutor does in investigating who issues the warrants, what the determinations needed to issue the warrants are, and how we got to where we are today?
Yeah, let me step back a little bit, though, because I want to make a few points to build on what Gabe said. The United States and Israel are not parties to the treaty, but they were both very involved in the development of the treaty. Matter of fact, the United States was a major advocate for the creation of the International Criminal Court, because what happened after the Cold War with the conflicts in the former Yugoslavia and Rwanda was every time there was a conflict with serious war crimes, genocide, crimes against humanity, the UN would create a new tribunal, and it was a very inefficient process. So the idea was that we would benefit from a permanent international criminal tribunal, but that tribunal by design was intended to be a fail-safe. It wasn't intended to be a substitute for national jurisdiction. It was intended only to be used when it was relatively clear that a state was unable or unwilling to hold its own people accountable. And the main concern the United States had that led us to ultimately decide not to join the treaty was the independence of the prosecutor, and that there was no real check on the ability of the prosecutor to allow political influences to dictate pursuit of charges against individuals. The United States obviously was very concerned about this because of the extensive involvement of U.S. military personnel in contingency and combat operations around the globe. So our fear was being manifested, I think, in what we're seeing today. Our fear was that there would be credible investigatory and disciplinary mechanisms used within the United States for our own people, but that there would be a prosecutor who could cavalierly decide that what we were doing wasn't good enough, wasn't fast enough, wasn't comprehensive enough. There's no double jeopardy principle that applies at the International Criminal Court. So you could have a situation where an American serviceman was prosecuted by a court-martial, acquitted, and then the ICC prosecutor had carte blanche to say that's not good enough, so I'm going to bring a case. So we're not party to the treaty. We were significantly involved in its development, particularly in the development of the list of crimes within the jurisdiction of the prosecutor. Now, if you're not a party to the treaty, that doesn't necessarily immunize your personnel from the jurisdiction, because if the prosecutor believes that one of your nationals committed a violation of the treaty in the territory of a treaty party, then the ICC prosecutor has prerogative to assert jurisdiction, and so does the court. That's what's going on now. Israel is not a party to the treaty, so the tribunal does not have jurisdiction over Israeli nationals as a result of Israel joining the ICC. However, the ICC has accepted the Palestinian submission to join the treaty as a state party. This was very controversial. Israel challenged it in the original application. I was part of a group of experts who challenged the legitimacy of accepting Palestine as a state party, but ultimately the court decided that it would accept Palestinian participation as a state party, but was only deciding that issue for the purpose of jurisdiction, not whether or not Palestine was in fact a state. Well, you see the consequence of that in the announcement yesterday, because the court rejected Israel's objection to assertion of jurisdiction based on the state status of Palestine, and also concluded that because Israel and Palestine are in an ongoing armed conflict, aspects of this conflict were international in nature, which has an impact on the jurisdiction over particular crimes. So what happens? The prosecutor can start an investigation, what lawyers call sua sponte, which means on his own initiative, or other state parties can refer a matter to the prosecutor and say, we're concerned about what's happening in this conflict. We want you to investigate. There were a number of state parties that did that initially vis-a-vis Israel in Gaza. So Karim Khan assembled a group of international law experts. I would say I know a number of them. They are highly distinguished experts in the field. I have great respect for them. Although I'll make this point later, I thought it was disappointing and unfortunate that he didn't include within that group of experts actual former military law experts, which would not have been hard to find. There are some great retired judge advocate officers in the United Kingdom, Bill Boothby, Darren Stewart, and they could have easily been included in this group of advisory experts. They weren't. The advisory group recommended a number of charges, and then he submitted his request for those charges to the pretrial chamber. So what happened yesterday was kind of like what we might call a preliminary hearing, or even not a grand jury, but more like a preliminary hearing. In many states, not at the federal level, but in many states in the United States, you don't have to use a grand jury to charge somebody with a crime. A prosecutor exercises independent initiative, proposes a charge, charges you with what's called a criminal information, and the screening of that is a preliminary hearing. That's what the pretrial chamber essentially did. They screened that proposal, but it's a very low bar. All they have to do is find that there's a reasonable basis in the submission that there was offenses were committed under the statute. It's not a contested hearing. So it's not like a trial. It's a very low bar, and it's very prosecution favorable in the sense that The prosecutor gets to muster what he believes is the evidence. It's not contested. To the court's credit, they did invite experts to submit amicus briefs to help them get another perspective. There were quite a few amicus briefs submitted. Most of them, I would say, weighed in favor of the prosecutor, international law scholars and experts around the globe. There were a minority of experts who said that this should not go forward. And ultimately, all the pretrial chamber is doing is looking what the prosecutor mustered in terms of evidence and asking a simple question. Would it be unreasonable to believe that these crimes were committed? Not were they committed, not have they been proven beyond a reasonable doubt, but would it be unreasonable to let this case go forward? And they ultimately unanimously concluded it would be reasonable to let the case go forward, and they issue the arrest warrants. And then, pursuant to Article 98 of the Rome Statute, all state parties bear an obligation to assist the prosecutor and the court in bringing indicted individuals before the court to answer for the charges. And that's why now, if you're a state party to the ICC, you now bear a treaty obligation if any of these defendants, including the Palestinian Deef who was charged, are within your jurisdiction, you have to apprehend them and turn them over to the prosecutor.
Just on this process of actually issuing the arrest warrants, if I remember correctly, Professor Korn, Karim Khan, the independent prosecutor, also sought arrest warrants for other Hamas members, notably Yahya Sinwar and his brother, and Ismail Haniyeh, I believe, as well.
They were withdrawn.
They were withdrawn because they're known to be deceased, whereas yes. Mohammed Deif, even though he is presumed to be deceased, it hasn't been confirmed, so they were able to proceed with that.
The court granted the prosecutor's request to withdraw those petitions, so to speak, but it's not clear enough that Deif is deceased. And I also think look, because I wrote it back in October, that one of my concerns about this conflict is that there was going to be a almost obsession for what I call the equality of condemnation. That the condemnation of Hamas it's manifest. I mean, there's no plausible argument that what they did on October 7th and thereafter, by the way, firing rockets at Israel, complied with international law, or that they're going to do anything to hold anybody accountable. But it almost seems like if you're going to accuse one side, you've got to find something to accuse the other side of. And that may have been an element, right? We're going to issue these warrants against the Israelis. We got to issue something against the Palestinians, or the court's going to look completely biased, or more biased than many people perceive it to be already. So perhaps the inconclusive evidence of death enabled the court to issue an arrest warrant. Although, ironically, even there, it's just bizarre that there's no accusation of intentionally attacking civilians by firing 10 to 15,000 rockets without a target at Israel, which goes to the whole problem of an over-focus on combat effects as opposed to what you're actually trying to do.
Now, on this topic of who is a party to the ICC, you said that states that are parties have a responsibility to bring people who have been have arrest warrants against them, bring them to the court. The state of Palestine, as it's recognized by the ICC, is a party. So does that mean that the Palestinian Authority and/or Hamas have a responsibility to give up Deif?
Yep. That's exactly what it means. They do bear that responsibility. Obviously, Israel doesn't bear a responsibility because they're not bound by the treaty. And this issue of cooperation with the court, I will tell you, when I was the chief of international law for U.S. Army Europe back in right after 9/11, where there was kind of a scramble by NATO forces to rent big training areas in the former East Bloc countries because it was harder and harder to do combat training in Germany. So we were negotiating agreements with the Czech Republic, Hungary, Romania, Bulgaria, to send U.S. Army units for large-scale combat maneuver training. And in every one of those agreements, one of the conditions was they had to sign a waiver of their Article 98 obligation, because we're fighting a war in Afghanistan and Iraq. We don't know if there's a sealed indictment against an American service member, and we didn't want to take the risk that we would send, Blaise Misztal with his armor platoon to Bulgaria, and when you land in Bulgaria, the authorities arrest you. So this was controversial in and of itself, because the states were being asked to sign a supplemental agreement that nullified their obligation under agreement they already signed. But this is how potentially dangerous this is for somebody who's a national, not of a treaty party, who might go somewhere where there is a treaty obligation and find themselves brought before the court.
If I could stick with you just a moment longer, Professor Korn, could you tell us about what the specific charges against Prime Minister Netanyahu and Minister Gallant are? What are they being accused of?
I mean, the two principal kind of vectors of the charging are focused on starvation, right? So the main charge is that they engaged in starvation as a method of warfare by intentionally depriving the civilian population in Gaza of resources that were essential to their survival: food, water, and power. And part of that is bolstered by the court's conclusion at this point that Gaza is subject to the law of belligerent occupation. This is a complex legal issue, but this is why the court's recognition that Palestine is a state becomes so significant from a jurisdictional standpoint, because the court says that there are actually two conflicts going on in Gaza right now. There is an interstate conflict between Israel and Palestine that is the result of Palestine being partially occupied. Because under the 4 Geneva Conventions, if you occupy the territory of another state, even if there's not active hostilities, then the law of international armed conflict comes into force. There's also a coextensive non-international armed conflict between Israel and Hamas, which is a non-state organized armed group. But the significance of that is the court asserts that Israel bears occupation obligations in Gaza, and that occupation obligation has a much more extensive obligation to provide for the needs of the civilian population than if you're not an occupying power. If you're not an occupying power, what's prohibited is arbitrary interference with humanitarian assistance. If you are an occupying power, you have much more of an affirmative obligation to provide for humanitarian access and assistance. But the court basically says that Israel has been responsible for violating the law on both counts, that their interference with humanitarian access has been arbitrary, not justified by any legitimate military necessity, and that they have not done enough to facilitate the provision of humanitarian access to the civilian population. And that is evidence that they intend to use starvation of the civilian population as a method of warfare. And then the other piece of it is widespread and systematic abuse and murder of civilians in Gaza, which leads to a charge of crimes against humanity. So murder, forcible displacement, cruel and inhuman treatment. When you engage in that conduct on a widespread and systematic basis, that is the foundation for what's called crime against humanity. So those are the major vectors of the accusation: starvation as a method of warfare, and crimes against humanity as a result of murder and inhumane treatment of the Palestinian civilian population.
And in your eyes, how legitimate are those charges?
Well, I told you that it's a low bar, right, to send a charge forward. This is not deciding whether these crimes have been proven beyond a reasonable doubt. And maybe some of the people on the webinar are not going to like to hear this, but I'm not all that critical of the judges on this issue, on the issue of whether there is a reasonable basis to support that accusation, because it's such a low bar. So what they're doing basically is they're looking at two sources of evidence. They're looking at the effects of combat, and they're looking at statements of government officials, and they're using that to say it is not implausible to infer this criminal intent. It's not implausible. They're not saying it's there. They're just saying it's not irrational or implausible. And on that level of evidentiary analysis, I think I can understand it. I told you before we started, I'm not sure if I were a judge on the tribunal on that question, I would have come out differently. My criticism of them is I think this is all premature. And it's been my criticism of the prosecutor from the beginning, right? If he had come out when he announced the effort to charge Hamas leadership and said, I'm also concerned about what Israel's doing, I'm going to stay focused on that and continue to interact with them and decide later whether I think they're credibly investigating what may have been violations of the law, whether they're dealing with government officials who are making inflammatory or statements that may have incited violations of the law. And then later I'll decide what to do about that. I think that would have been a very credible statement, but that's not what he did. And again, this is this equality of condemnation, right? They come out at the same time. I wish the tribunal, and this was the focus of the amicus that I did with the high-level military group, part of the focus was premature, that the court is not supposed to jump in and substitute for national jurisdiction. It's supposed to let states let their process work. I don't think there's sufficient evidence to say that Israel is incapable of investigating itself. We have the Turco Commission. We in other offenses that are not related to international law, just domestic criminal offenses, you have an Israeli president or prime minister that was convicted and sent to jail. So why is it so important to start this now? And that's where I think the pretrial chamber should have kind of rejected the request, not to say that there isn't some plausible basis to be concerned there may have been war crimes or violations, but that it's premature and we need to let Israel conduct its own investigations and see what they do and see if they're credible. And again, you know, this goes back to, I think, if a prosecutor can get to this point relatively easily, which we see, the burden is really on the prosecutor to be really cautious about overreach and overzealousness. And I've written about an op-ed about this as well. And I think that that is the real problem here. It's not so much the tribunal, the pretrial chamber, it's that they were asked to do this when they shouldn't have been asked to do it. Not yet. Maybe down the road, there's enough evidence to say Israel's not taking this seriously. We need to do something about this. That's a different case. But the prosecutor came out, blindsided Israel. He was in consultation with them. Their understanding was he was going to wait and see what they were doing. And then he blindsided them with his announcement of seeking the arrest warrants. And so my main criticism is focused on the process that led to this request, not as much the outcome of the request. I think it was a foregone conclusion.
Did just on this topic of the sort of the sufficiency and credibility of the Israeli national justice system, was that something that the prosecutor in requesting the warrants addressed, or that the pre-trial chamber in issuing the warrants weighed in on, or was they didn't consider that at all?
On your first question, we're not really sure. Much of the submission is still confidential. We don't see everything the prosecutor has provided. So in a way, we're shooting in the dark. And who knows, maybe there is some other compelling evidence that we haven't seen that the pretrial chamber saw, and that when we see it, we'll be a little bit, you know, contrite about the criticism and say, well, you know, we didn't know about that. But no, I don't recall that being a major part of the discussion. It was just almost an assumption. And that also may be reflected in who's been targeted, right? Notice that the prosecutor hasn't gone against any subordinate military officers. And maybe that's because in the prosecutor's view, the Israeli military justice and criminal justice and investigatory system is credible and adequate for dealing with potential misconduct of people in uniform, which I would tend to agree with. But maybe the perception was the high-level political leaders are functionally immune from accountability in the Israeli system, and therefore that justified going after them at this point. It may very well be a key element of his theory. It may have been part of his submission to the pretrial chamber. there was a line in the statement from the pretrial chamber that said something to the effect that Israel never formally declared that we defer looking at the, or formally requested. I think that's formalism over logic, right? I mean, it's very clear that Israel was opposed to this action and was trying to cooperate with the prosecutor. That's public knowledge. I think the court could have acknowledged that. I was teaching a case yesterday, completely unrelated, and on the state secrets privilege. And there's a line in there by Justice Gorsuch in his dissenting opinion where he says, at some point, even judges have to acknowledge that we're still citizens and we can't be blind to what's obvious. He was basically saying what I think the court should have done was to say, okay, maybe Israel has not formally requested a deferral of this process, but it's obvious to us as judges that they think this is an unjustified intrusion of their sovereignty and a premature action by the prosecutor, and they're opposed to it. So, I mean, that was a little piece on it, but as I said, I think it's formalism over logic.
Thank you, Professor. Gabe, let me come back to you. What has the international reaction been? What have U.S. policymakers said? And there's over 120 parties to the Rome Statute, as you said earlier. Do we know how they're reacting to these arrest warrants?
So we're sort of still seeing a lot of responses coming in. For most of the European and other Western leaders who have been asked, and they're often asked in front of cameras when they don't appear to be 100% prepped on this by their lawyers yet. But what they've said is something to the effect of, we will follow the law. We are obliged to honor ICC judgments and to carry out their orders. But you've also seen broadly some reticence of not wanting to overcommit directly, that they would say specifically go and arrest Netanyahu or Gallant in the event that they land in their territories. I don't think that they want to be quite so provocative as to basically indicate that they are now persona non grata in those countries. However, what we've seen is Canada, France, Italy, Sweden, Switzerland, Netherlands, Norway have all basically said that they intend to follow the ICC's orders so far. Hungary is the only ICC party who has gone out and said, we do not intend to honor this at all. He is welcome to our country. I suspect we're going to see a lot more countries over the next month or so start issuing relatively formal guidance on how they are going to interpret this. The United States, we've seen a aggressive outcry in Congress, particularly among Republicans, but also a lot from Democrats as well, threatening basically that it is time to sanction the ICC and that this was a totally illegitimate process, which I think we'll get into the sanctions question a little later. But obviously the United States is not a party to this, so it's not obliged to carry out these orders. But there's varying levels based on how people view the underlying accusations. One thing that's, I think, particularly interesting is Joseph Borrell, who's the High Representative for Foreign Affairs for the European Union, has come out and said that he urges all European countries to abide by the ICC's orders. The good news for Israel is that Borrell has only 8 days left in his tenure. On December 1st, we'll see the Estonian Defense Minister come in and replace him. She has espoused much more favorable views towards Israel, and I don't think I would expect to see that kind of animus towards Israel going forward. Broadening out a little bit, I think there's the legal and then there's the political. I certainly bear no candle to Professor Corn's legal prowess. On the political side, to me, this strikes me as highly effective, highly disruptive lawfare on the ability to disrupt Israeli leaders' comfort and ability to conduct diplomacy and travel to upwards of 120 countries is one of the most pernicious and effective uses of again, lawfare against Israel that we've seen. Contrasting this with some of the other targets of campaigns like this, Putin is under a similar warrant from the ICC, and that is on account of his unprovoked and illegal invasion of Ukraine and the various war crimes that have been committed there. And then if we're to use historical analogy, perhaps some of the international blockade around South Africa during apartheid. I think from a political perspective, the notion that Israel is on par either with Putin's invasion of a sovereign country or with the apartheid regime in South Africa's treatment of Black Africans is I find that baseless. And so the question is, at a political level rather than a legal level, how does the international community, how do the allies of Israel respond, I think is a question. One other point, and I agree completely with Professor Korn on, I think for me, the original sin here is the question of Palestinian participation in the ICC process to begin with. And what I would caution is this ability for questionable states of questionable legality, for example, entering the ICC and then gaining access to its prerogatives. As an analogy, I'm not comparing, for example, the entire Palestinian Authority to ISIS, but if ISIS at its height of its caliphate had applied and earned ICC privileges, and then they had attempted to use that against, say, US and counter-ISIS coalition forces who were taking out their troops, that to me is an example of abusing the legal system to effectuate outcomes that are not consistent with the privileges that a state earns. A state should earn privileges when it acts in accordance with the responsibilities of other states. If it doesn't act accordingly, it should not receive the privileges of statehood and the accompanying privileges in international institutions.
Thanks,
Well,
Gabe. I saw you wanted to jump in, Professor. Go ahead.
Yeah, when the tribunal considered that, they did consider how many member states had recognized Palestine. And there are a lot of member states that had already or since subsequently recognized Palestine as a state. So, for the tribunal, it wasn't as if the judges on the tribunal just arbitrarily got in a room and said, hey, should Palestine be a state? So I think look, I opposed it. I think that the reason I opposed it was because I think these recognitions undermine the ultimate goal of Oslo, but there is also a strong sense that Oslo is functionally dead and nothing's happening and this is the way forward. And I understand that. But to allow the court to kind of jump into this extremely complex diplomatic, political issue and tip the apple cart, I thought was a concern. And the other reason I thought it was problematic was because, believe it or not, the United States and Israel can participate in the ICC, especially the United States, because the ICC has a provision where the Security Council can refer a matter to the prosecutor over an individual that would otherwise be immune from ICC prosecution. So, in a sense, by recognizing Palestine, the court usurped the function of the Security Council. If the Security Council wants somebody from ISIS or Palestine to be subject to investigation, they can always vote a resolution and send the case or send a request to the ICC prosecutor. One other point, I will just say, I think we have to be careful with this characterization of lawfare. It's used a lot. The guy who should have copyrighted that term was Major General Charlie Dunlop, who is a professor at Duke University. He was the one to first write about it. But I think we have to acknowledge that law is a weapon system, especially criminal law. It's a weapon system against impunity for serious crimes. At the international level, the ICC exists to respond to impunity for serious violations of international law. That in theory is not a bad thing, but like any weapon system, it's subject to abuse or misuse. So the real issue is when you vest institutions and individuals with discretion to leverage the weapon system, the bar should be extremely high on them following the principles of law and the institution that they serve. And I think that that is the real legitimate source of criticism of what's happening here. Again, there's no urgent need to rush this process. The pretrial chamber could have easily said, not now, not yet. Let's wait. Let's let the principle of the institution play out, which is allow Israel, which has a very credible legal system, to do its job. And if it fails to do its job, we can come back and revisit this. So that to me is the part of this that is an abuse of the institutional ethos that the court was actually founded on.
And is there any legal recourse? Is there any precedent for arrest warrants being rescinded, or is there a higher court that can be asked to weigh in on the legitimacy of the arrest warrants or the charges, or are we sort of stuck with this now, Professor Korn?
Well, imagine you're a defendant in Maryland and an overzealous prosecutor charges you with the crime of wearing a blazer over a sweater, and you think it's an unjust charge, right?
Luckily, I live in DC.
Okay, so you're not even in the jurisdiction, but you were visiting Maryland, so you get the point. Normally, the way you contest this is you appear as a defendant and you file a motion to dismiss in front of the trial chamber. The problem is, to get that remedy, you've got to submit to the jurisdiction of the court. Israel can't send a supernumerary for these two defendants and say, we're going to send Misztal. He's going to be the guy that pretends to be Netanyahu and he'll file them. No. So this is one of the ironies here. The validity of these charges as legitimate claims of violations of international criminal law can only truly be tested by trial. But to test by trial, you have to submit to a jurisdiction you think is inherently invalid. So, Gabe talked about the political consequence of this. I've seen some commentators say this has no effect because they'll never get their hands on them. That's absurd. This has profound shock effect. This reinforces every critic of Israel. It will be used as confirmation of the worst narratives of what Israel has done in this conflict, including the IDF, with no real opportunity for rebuttal or to demonstrate the overreach that people like me, and I recognize I have a bias and I'm in a minority, but people like me perceive to be at the heart of this accusation. And that's the dilemma here. It's never going to end up being like a decision like with General Gotovina, where he was convicted by the tribunal and then the appellate court reviewed it and reversed his conviction, and it's in all the international criminal law books and you can study it. It's never going to be that. It's going to be the charging case. And so it's going to mean what people want it to mean without ever being fully litigated. And that, I think, is really unfortunate and is why this is much more significant from a political and diplomatic level than it is from an individual criminal responsibility level.
So with that, Gabe, let's go to the political and the policy. What recourse, what options are available to the U.S. to try to quash some of the negative implications that Professor Korn just talked about, and didn't Congress already try to do something about this?
So the House of Representatives passed a bill that would entail mandatory sanctions against the ICC and its senior leadership in the event that arrest warrants were issued against Israeli leaders. This was a bipartisan bill. It had, I want to say 74 Democratic co-sponsors and then a majority of the Republican caucus. And it passed earlier this year out of the House of Representatives. It passed out of the Senate Foreign Relations Committee, similarly in large bipartisan margins. And it has been currently sitting on the Senate floor, waiting for Majority Leader Schumer to take it up. There was an original commitment by Majority Leader Schumer to take up that legislation. Then that got caught into a dispute, and it's actually caused a huge blockade of nominees for ambassador and State Department positions because the Senate Foreign Relations Committee Republicans have called foul on this. Regardless, to say it's unlikely to see the light of day in this Congress, but in January, the incoming Majority Leader, John Thune, has promised to take up this legislation. Presumably a Republican House will likewise renew that legislation, and that's going to go into effect. This will entail mandatory sanctions against, again, a number of ICC leaders, prosecutors, which is going to have a significant effect on the ICC going forward. My understanding, and Professor Korn can correct me if I'm wrong, is that the arrest warrants are effectively, once they're out there, that the court itself is unable to take them back and rescind them on their own accord. I don't know if that's
not the pretrial chamber, right? Remember that the trial chamber actually dismissed the charges against the president of Kenya, but that's because, or the former president of Kenya, but that's because he appeared for trial. So yeah, I mean, they're just out there, and unless either of these defendants chooses to appear to contest these cases, there's no real remedy.
One thing I would note is that the sanctions which are going to be promised by Congress, and which I fully expect will be passed into law in a couple months, the ICC has had a lot of fair warning on this. There have been a number of senior conversations between Senate leadership and Karim Khan, the chief prosecutor of the ICC. They warned very specifically that this would be the outcome, that it would be basically full political warfare from the United States against the ICC if they went down this path. So the ICC proceeded with full knowledge, I think, of what's about to happen next. In the first Trump administration, the United States under Secretary Pompeo also issued sanctions against a couple ICC prosecutors who were involved in prosecuting U.S. soldiers for crimes in Afghanistan. I think what you are going to likely see from a Secretary of State, Marco Rubio, is a similar desire to go aggressively after ICC leadership. That's going to change the nature of the court. Part of it is it's now also going to completely derail the ICC's efforts against Putin, against warlords in Africa. In the view of certainly the Republican Party, which is now going to be in control of all three posts of power in January, the ICC is illegitimate, it's done, and there's no desire for it to really exist in any form anymore. That's a tragedy in the sense that Professor Korn laid out of the need for permanent tribunals against what many Republicans view as the original targets of what the ICC was supposed to prosecute. Again, a lot of views of this was built for African warlords who were going and doing these things, and not for difficult political questions on which there are split opinions and which the international community is divided over. That is where I think, from a political question, the ICC exceeds its political mandate. It has a legal mandate and it has legal rules, but also has a political mandate of what can it reasonably do with legitimacy, and where it oversteps its bounds politically and gets over its heels, and then no longer will have broad perception of legitimacy among the actors who are supposed to be enforcing its rules.
Gabe, do you have a sense of why Senator Schumer, who calls himself Shomer Israel, the protector of Israel and Jews, why he would have held up this legislation if we knew there was a very real chance of these arrest warrants coming down?
This was based, my understanding is based on a request from the Biden administration, who objects to these warrants, but has, if you look at a lot of the lawyers who work in the Biden administration, there's a long history of cooperation with the ICC. A lot of the folks in the Biden administration work very heavily to work on the arrest warrant against Vladimir Putin, for example, as did, say, Senator Lindsey Graham and other Senate Republicans. And so there's a sense from Majority Leader Schumer to not throw the baby out with the bathwater, and that there's a view that this can be fixed and maybe isolate and target consequences a little bit more narrowly. I'm interested to see whether the Biden administration imposes its own sort of narrow targeted countermeasures in the next month to try to have a consequence there without, again, disrupting the entire system. I sense that the political trajectory will simply bowl it over in 2 months from now.
Hey, Blaise, we
Yeah.
should also keep in mind that there's an ambassador in the State Department for global accountability, Beth Van Schok. So one of the dilemmas you have with cases like this, I think Gabe raises this, is you have to make a decision. Are you going to be more influential by staying inside or isolating them? And I think that some of the reaction by the Biden administration is a manifestation of the view that we could be more influential if we stay engaged and try and influence. And I think that view is gone now. And I think that Gabe is right. As soon as the new administration comes in, they're going to drop the sanctions hammer on the ICC and try and separate ourselves from any involvement. And that's not going to kill the ICC. It's still going to be there, and it's still going to be doing its function. So it's a very, I think, difficult policy judgment. How do we best influence this institution? And by the way, that comment about created for African countries, actually, was one of the negative perceptions when it began, because all of the cases seem to be coming out of Africa. And again, you worry about political influence here. Was there some sense that we've got to find somebody from a non-African country to make a big case about? And, one of the greatest Supreme Court justices in American history was Robert Jackson, who was the Attorney General of the United States before he was the Justice of the Supreme Court. And he gave a speech to the U.S. attorneys, and he said, one of the greatest dangers of a prosecutor is that you target people and not crime. In other words, you look for someone you want to get, and then you find a crime to charge them with, as opposed for looking for crime, and then whoever commits it is who you go after. And I mean, this has had that flavor from inception. And the other thing I want to point out to the group, don't overlook the symbolism of the date of the arrest warrants. It was on November 21st, 1945, that Robert Jackson gave his opening statement at the Nuremberg Tribunal as the chief prosecutor for the International Military Tribunal that tried the high-level Nazis. So I don't know if that had any influence, but it seems more than coincidental that the date these arrest warrants are issued are the same date that opening statement was delivered at Nuremberg.
Gabe, you've talked a little bit about the likely U.S. response against the ICC, and if not now, then come 2025, that's coming. But are there policy options for trying to get countries that are parties to the Rome Statute not to execute these warrants against Israel? Is there anything that can be done on that front?
I apologize in advance. There's some drilling outside my apartment. There's certainly a huge opportunity for the State Department here to engage in outreach to all of our partners and ask them to basically have statements indicating that Prime Minister Netanyahu and Gallant are free to visit countries and that they will not abide by this particular ruling. Again, this is something more on the legal channels. Typically, the Department of Justice actually sometimes has more active legal channels than the State Department does many of these cases. But it's going to be difficult. That's a very time-consuming process to do this. I've done this for other similar methods, especially when you're going through legal channels. Making these requests is technical. It requires a lot of diplomatic bandwidth, and it does not often bear a lot of fruit in foreign legal jurisdictions. When we are trying to make a legal argument, it often doesn't hold much water with foreign lawyers. There are more coercive methods that have been suggested and introduced in legislation, things including mandatory penalties for any nation that does enact and enforce these arrest warrants. I suspect that you're going to see some of that be either threatened by a future Secretary of State and President, or perhaps even codified by Congress, that there would be mandatory economic and diplomatic repercussions for any nation that executes this.
Let me turn to some questions that we have from the audience, and if anyone else has questions, please feel free to submit them using the Q&A feature, and I'll read them out. Professor Korn, we have a question about who acted on behalf of Palestine, who made the complaint?
Well, there were a number of state parties that referred the matter to the prosecutor and said, we're concerned about what we're seeing. We want you to open an investigation. But ultimately, it was the prosecutor who was bringing this charge. I mean, this is a principle of criminal law in any jurisdiction. It's not a case of Palestine versus Israel. It's a case of the ICC versus these two defendants and the one defendant from the other side. So the prosecutor, by virtue of the treaty, is the entity that represents the interests of the international community, or at least the state parties to the treaty, in deciding who, what, when, and how to proceed criminally. There is no Palestinian entity that's in the room there saying you need to take care of us.
And let me maybe go back to something that you had mentioned earlier, Professor Korn. You had said that, in a previous capacity, you had negotiated agreements with other countries not to potentially arrest U.S. troops who might have had arrest warrants issued against them. Is that something that would be possible to negotiate with other countries going forward in sort of military to military agreements as a condition of receiving U.S. military assistance or other forms of diplomatic activity?
Yeah, well, first, a qualifier. I participated in the negotiation. Yeah. I wasn't the lead negotiator when I was a lieutenant colonel in Germany. But yes, I mean, I think that interestingly, what the United States did after 9/11, when we were doing these basing agreements, these status of forces agreements, serves as a precedent that Israel, or even, as Gabe says, even the United States could tell other countries, we're going to condition certain aid on you entering into a bilateral agreement with Israel, committing not to enforce your obligations under Article 98 of the treaty. It's, from an international law perspective, it's very controversial, but states are sovereign. And the ICC prosecutor can't make a state do anything. President Bashir of Sudan is under criminal indictment by the ICC through the UN Security Council referral. And he's traveled to South Africa with impunity. I mean, the irony of South Africa, the icon of enforcing international law going before the ICJ, but when Bashir shows up for some event in South Africa, they completely ignore their obligation under the Rome Statute. States are sovereign. They have the prerogative to do that, and the ICC has no remedy for that. They can't send the ICC policemen into Hungary or Bulgaria or the United Kingdom and say, we're going to apprehend somebody. The court is completely dependent on the cooperation of member states to enforce its authority.
Gabe, let me just turn with one last question to you, and then any closing thoughts that you have. We have a question asking for clarification about the Biden administration and Schumer holding up the sanctions against the ICC. If you could sort of clarify what you said about the administration believing it's better to have influence from the inside.
Sure. So I think here's what if the bill that has been advanced by the House and part of the Senate advances, here's what it would actually do, and I'll actually read a little bit of the law. It's that any individual who is engaging in any effort by the ICC to investigate, arrest, detain, or prosecute, basically Netanyahu or Gallant, or has provided material assistance, provided financial, material, or technical support, or any goods in support of the ICC's efforts to do this, they would have all property blocked in the United States, They would be inadmissible for any visas of any kind. Any of their current visas would be revoked. So again, that's the scope of what we're talking about, which would likely, depending on how aggressive the administration enforces such sanctions, would go very deep. So that will likely prevent any of those officials from coming to the United States for any kind of meetings about other matters. It would not, however, prevent U.S. attorneys going over to The Hague and talking about a matter about Russia or another issue. But it would prevent any of them from coming to the United States. It would prevent them. The material support is a very tricky word. There's debate whether that means you're not allowed to be a Marriott that hosts this person, even if it's a European Marriott, for example. So there's a lot of questions about the particulars there. But again, this is something where the executive branch has the discretion on how it implements and executes sanctions on this. So I think there is probably a lot of concern from Majority Leader Schumer that a future Republican administration would be a lot more aggressive in its execution of these sanctions. In terms of what the future will mean, I struggle to see a lot of, certainly for the next 4 years, really any cooperation whatsoever. I think at the top leadership level, there's, in my view, likely going to be a directive that says you're not talking to them for 4 years on any matters. Now that will then hopefully spark a attempt from the ICC to moderate its actions, and they will try to sort of work back to a place of cooperation. I suspect the next year is going to be a very cold and ugly year in the relations, though, and then we'll see how it gears back in a few years.
Really quickly, Gabe, because we have 2 minutes, but do we know if there were behind the scenes efforts by the Biden administration to talk the ICC out of proceeding with these? Is that why they were trying to hold the legislation to see if they could affect change sort of in the back rooms, or?
Yes. So there have been ongoing efforts that I've been aware of for the last year, of senior congressional leadership delegations talking with ICC leadership, of the Biden administration talking at senior levels with the ICC leadership, and even the Israeli authorities themselves talking to ICC leadership. There were offers for ICC leadership to visit Israel, to do site visits. And on the eve of those visits, instead of coming and doing actual investigations, was when they announced that they were going to proceed in the pre-trial. And that was when you saw the flashy video from Karim Khan, flanked by 2 of his prosecutors, announcing all of this. Again, and this is one of the things that has soured and poisoned the well, so to speak, is there was a good faith effort from a lot of senior executive branch and legislative branch individuals at working towards a thoughtful compromise. And they've been burned, and they believe that they've been burned, and they believe that they've been lied to, most importantly. And that includes, I believe, Majority Leader Schumer, and a number of Democrat leaders and Republican leaders in the Senate who were on conference calls and who I've been told by their staffs that they were explicitly lied to by Karim Khan and his associates. That does not bode well.
Same perception in Israel.
Yeah, and so that, I think, to Professor Korn's point about process and prematureness, things like that lose a lot of confidence in the institution as a whole. That if that's how they're proceeding on a matter like this, what does that say about the court as an institution?
Exactly.
Broadly?
Exactly.
Well, I think it's an understatement to say that this has been incredibly disappointing, and that I think there are going to be consequences for the ICC as a result, which we'll of course track and be part of. So please stay tuned to JINSA for more updates on how this all unfolds, including the sanctions legislation that Gabe has talked about. But let me thank Professor Korn. Gabe, thank you for joining us at short notice today. Thank you all for tuning in, and have a good weekend. Shabbat Shalom, everybody. And we'll obviously keep you updated on this important development. Thank you.
Thanks, Blaise. Thanks, Gabe.